I sent him late. And he did that.
Well, here we are at the Joint Planning Law Conference 2014 at the Oxford Union. And the title of this year's conference is Power to the People, ? And we're going to attempt a first for the JPLC. We're going to try and video a panel discussion arising out of the issues at this morning's conference. My name is Michael Humphreys. I'm a QC at Francis Taylor Building, and I've invited a number of guests to join the panel. First, I've got Geeta Parihar, who is the head of legal at Friends of the Earth, and Simon Ricketts, partner at King & Wood Mallison, S.J. Berwin. And Geeta and Simon gave papers this morning. But I've also invited Jake White from Friends of the Earth, Duncan Field, partner at Ragg Lawrence Graham, Robert Evans from Argent LLP, and I'm hoping we'll be joined as well by Rory Joyce, now at Brunel Planning. The discussion is going to focus on the issues in Geeta and Simon's papers, which had the joint title, Challenge and Protest in Planning. Well, I'm here now with the panel, and I'm with Geeta, Rory, Robert, Jake, Simon, and Duncan. And we're going to start, Simon, with something for you. In the paper you presented this morning, you made this point that up until the kind of 1970s, early 1980s, the planning system delivered the big infrastructure. It delivered airports, motorways, the national grid, big infrastructure. But then something happened, and after that, there was much more legal challenge to decisions. Why was that?
I think we have to be careful not to generalise, but there has certainly, regardless of the statistics that various people promote about the use of judicial review, I think all of us would recognise that it's much more routine now for there to be challenges of major decisions on potentially controversial projects. And I think it's a mix of things. I think it's the greater preparedness of people in the country to rely on the courts whenever they have an issue, rather than simply play to the referee's whistle. But also it's because we have much more regulation, and of course the European layer of regulation, which gives far more creative opportunities for people to find the loopholes. And then lastly, I think the mystique has been taken away from the judicial review process simply because it has been used much more, and there are firms that regularly promote themselves as acting for challenges. All this has had an effect.
But you kind of pointed to two things which it seemed to me gave us a flavour for why it was that period, the late 70s, early 80s, that things began to change. And one was you pointed to the change in 1977 to the rules of the Supreme Court, which introduced what we would now regard as the modern law of judicial review rather than the old prerogative writs. And also in the early 80s to the EU EIA directive. I wondered though, are there other things? For example, we know during the 1980s a lot of the nationalised industries became privatised. A lot of our utilities were then, things were provided by private companies. Did that change perceptions? Did people think that that played a part, or were there other things that caused this change?
Well, if I chip in there, Mark, there were other things. There was a big social change. It became much more respectable to challenge decisions being made by others. Do you remember consortium developments? The house builders got together and said, we're going to build new towns. We needed new towns. We weren't building enough houses then. We're not now. And it is coming back now. Consortium developers decided the best way to do it was to get together and fight big public inquiries. Get the public on board, very, very aggressive. They lost every single case, but at that time you had a public who got used to the idea of it's respectable to challenge, respectable to turn up. That level of protest, you could do it through the system, and that was part of what happened at that time, which led to a lot more public involvement in decisions where previously they would have done what the referee said.
I think there is a difference here between sort of protest and engagement, and I think that public engagement is a very positive thing, and the fact that there are now better rules to enable that engagement to happen is actually a really good plus. So we have better rights of participation, better rights to access information, better rights to challenge, to take cases to court and some level of cost protection. I don't think we're anywhere close to where we should be, but the fact that this has happened has actually meant that there is a better scrutiny of decision making by the public, there's a better engagement, and there's a better weighing up of what those consequences of those decisions are.
I mean, is there a paradox there, though, that with a system that has moved to better engagement, I mean, a separate comment, people may want to comment on whether that engagement is sufficient, but better engagement is actually one that is a system where there seems to be more legal challenge rather than less legal challenge. I mean, any thoughts on that?
Well, I think the grounds for legal challenge are still very limited. I mean, you have, essentially, has the law been followed? Has a fair process been followed? Was it mad under most circumstances? So the rights and wrongs are generally outside the purview of the court. So in order to look at what you can challenge, and when you consider also what's the cost risks, no member of the public or community or NGO would take that case on lightly because they know what the consequences would be. So I think there's a perception, perhaps that it's being used in large numbers, but whenever one considers one looked at the statistics provided in the two most recent sets of consultations on changes to planning JRs and JRs, it didn't really, beyond immigration cases, there didn't seem to be anything, no statistics that actually substantiated that.
You have to be very cautious with those statistics, and I would say that one statistic which is undoubtedly right is the very few cases which are brought that actually pass the permission threshold, and I think it's fine for people to be able to bring judicial review, but it's just that those cases need to be sieved very quickly, and that is what the government has sought to do with a number of the changes, and that must be a good thing for everyone, I'm sure.
Go on, Robert.
Well, I was just thinking the point about nationalisation and those changes. I think those subtle changes, well, they were big changes, but then subtly they have had an impact. I think I was reflecting actually this morning that I read a book a while ago by a chap called David Halpern that's involved in government called The Wealth of Nations, and one of the points he made is that the UK has the lowest overall level of trust in institutions of any country in Europe. Now, most countries have a lot of trust in the private sector and not the public, or the other way around.
Right.
And we have this curious situation where public trust in both is actually pretty low, at an all-time low, actually. I think that's part of what's happening, actually. I think there is just a lack of trust in whether it's the private sector or the public sector. I think that's for a number of different reasons, not necessarily just to do with the way that the law has changed, but interestingly, people do seem to have more trust in the legal system than they do in democratically elected representatives to make decisions on planning. They don't necessarily always like the answer, they'll continue to pursue it through higher and higher courts, but there is a level of trust in the legal system. And it's interesting how that, it isn't democratic, it's not elected, but trust in the legal system seems higher than it does in our other institutions.
But it's independent, so fundamentally it's uninfluenced by political considerations or pressure.
Or financial considerations.
Or financial.
And interestingly, actually, there's a survey, I can't remember the details of it, but it points to a very high level of trust in NGOs as well for that reason. So they are more trusted, in fact, I think, than governments and potentially businesses.
I mean, one of the points, Gita, this morning that you made by reference to the Aarhus Convention, the first pillar, access to information. I mean, again, going back to my theme of kind of what was happening around the 70s and 80s to suddenly bring about change. Well, to descend to the prosaic, one of the things that was happening was much greater access to things like computers, copying. Documents got longer. If you look at law reports from 100 years ago, there'll be about 60 pages. If you look at 6 pages, if you look at them now, typically 60 pages. Why? Well, because you don't have to write out judgments in manuscript. And I wonder if a combination of sort of things of that sort of technology allowing us to have more documentation, as Simon had said, more regulation, greater access to environmental information, means now that there's just much greater opportunity for challenge, perhaps in a way that at the time of Stevenage just didn't exist.
I think access to information certainly allows for greater scrutiny, and that has to be a positive thing. It's important to ensure that our democratically elected officials, to decisions taken in the public interest are genuinely taken in the public interest, and to have that opportunity to understand on what basis information decisions are being made. I think the key thing that we haven't covered is certainly from one aspect of consideration is climate change, and understanding more about the impact of some of the developments that are being proposed. So the impact of big infrastructure airports, like projects like airports, for example, or big roads, or other schemes which could potentially have quite dramatic consequences for our ability to live within the budgets that effectively we have left if we want to continue to have a viable planet in which to thrive. So I think those sorts of issues are much more front of mind. I think we have a more engaged public. I think the internet has contributed to the people being the holders of knowledge, not simply being public authorities that you then try and get information from. There's very many other sources of information, and people are able to be part of things in a way that just wasn't possible.
We do know that under the systems now people do have an opportunity to be involved, to have their voices heard. And I think what I'm interested to try and understand, picking up some of the themes from this morning, is why is it then that now people, despite those opportunities, seem to feel that the need to bring legal challenge? Any thoughts on that?
I think it's very often the legal challenge is on a collateral issue which doesn't actually, which isn't based on the main substantive problem that they have with the development, but it's the opportunity to
I agree with
bring the decision back to the decision maker for reconsideration, or to postpone the development and to open up opportunities for thinking again. Not always, but that's often the purpose of the challenge. And so again, the government's approach must be right, of ensuring that challenges are heard quickly, even if they get permission, so that it can never be a reason to bring a challenge that you simply want to delay development.
What about the point, and I'd like to put this out there for people to comment, one of the speakers in the conference this morning in the question and answer session made the point that very often challenges appear to be brought on the basis that it's something in the public interest, where actually it's in fact the private interest, the personal interest that people are interested in. They are using the public interest as a means of achieving a private aim. I mean, is that the point was put? Is that fair?
I struggle a little bit to. I think all environmental cases, as we discussed this morning, the really powerful thing about the Aarhus Convention is it recognises that there is an inherent public interest in bringing environmental cases, because the environment is something that is of legitimate concern to everyone, and yet is something that needs representation, is not going to be protected off its own bat. And for that basis, all environmental litigation is considered to be in the public interest. That's the broad framing of the Aarhus Convention. There may sometimes be also elements of private interest, but it's not a situation where you're going to lose your life or limb, and yet people will still take the cost risk, and then these are significant risks. And I also take issue with the fact that people just claim. It's a very difficult thing to do. It's a very challenging thing to bring a court case. It's a very stressful thing to do, to bring a court case, to make sure that you've covered the cost if you're going to lose, to go through the actual stress and the technical and legal hurdles. I just don't agree that this is something that people just will, go off and do on a whim because they just want to obstruct something. I think there is a fundamental, deeper concern here, and my concern is that these aren't really coming through in our system. There's not a way for these to be really addressed within the legal system.
Makita, there are two things happening here. One is somebody with a legitimate concern, environmental concern,
Yes.
saying, I need a way to get this out into discussion.
This is your cases.
And what you're talking about is a private company, competing developer on a site next door, taking your development to the high courts on the basis of an environmental issue, because it's quite fruitful to go into the European legislation, find something and claim there's an issue there, when in reality it's a commercial objection. In reality they're saying, we want you to sell your site to us, it becomes a better site and such like. None of that comes above the parapet. This is just a commercial development, and it goes through the courts, all the way through Court of Appeal, and at the end of it, a decision is taken. That is precisely what you're talking about, and that does occur.
It does occur, but I also think, I mean, I speak from experience, the courts are alive to that. But I actually take the view that we shouldn't be worrying about motive. If the issues are important and they're being heard by the court to ensure good decision making, that's what matters.
Yeah.
And it doesn't matter whether you're a commercial,
If you're arguable.
competing developer, or you're an environmentalist or a private individual who doesn't want his views were.
This also seems to me to be, maybe this is a slightly overly technical legal point, but there seems to me to be a sort of protection built into judicial review, which is that you require permission, which you don't require in any other form of civil proceedings. So it seems to me that actually, in a way, judicial review builds in its own protection against cases which are in some way merely seeking to delay and have no merit, because they get weeded out at that stage. So
It's a low barrier though, isn't it?
Yeah, I'm not sure they do.
Barrier.
I mean, actually, I'm not sure how many cases there are like the ones you're describing, but equally, I think the barrier, the level of the bar for permission is actually set very low. It's my take on it. I think the more difficult area is not the commercial ones. It's where somebody plainly lives locally to something. They probably weren't an expert on the topic before the proposal was announced. Their initial reaction to it is one of natural concern because something's going to happen in their local area. And then they become interested in the subject, and you get people who become very knowledgeable about particular issues. And a lot of the issues that get aired are then environmental issues. And I agree with what you're saying. In the end, you look at the merits of the argument. In the end, motives become fused. You get a mixture of personal, growing knowledge of a subject that would never have started if it hadn't been for the proposal. But it still doesn't mean that they're necessarily wrong. I mean, in the end, you get a fusion of motives, and in the end, all you can do is look at the merits of what's being put forward. We can judge it on that basis.
I would say, first of all, it is relatively easy to bring proceedings now, and the Aarhus cost protection has certainly had an effect which makes it more palatable for people to bring proceedings.
Can I kind of then move us on? Because I wanted to start, as I say, with that discussion of kind of what happened, what was it that changed in society that meant that we now have more challenges. And I want to move on now to in effect, some of the broader issues around the changes to the judicial review regime that are now in place. And Simon, there was a sentence in your written paper, which I think you actually used this morning in the presentation. You said, judicial review has grown from an exceptional remedy of last resort to the predictable next step for a determined objector looking to frustrate or delay a development. Now,
Yes.
fairly clear statement that. Just say something about how you think the latest changes to the judicial regime are seeking to address some of the issues that I think you're implying there.
Yeah. Well, first of all, to make sure that if a claim is brought, then it's disposed of quickly. Either if it's totally without merit, to dispose of it very quickly indeed. If it's unarguable, but the person wants to try their hand in front of a judge, make sure that happens quickly. If it's arguable, the full hearing happens as quickly as possible. That, to my mind, is the most important thing, and the way the planning court really now has a much better understanding of the sort of cases that are coming again and again before the courts. But I think perhaps the government could have had more courage and included in the Criminal Justice and Courts Bill its initial proposal to restrict the rules on standing, which I know will be controversial, but I see various cases where claims are brought on a very dubious standing basis. I refer to the Richard III case, the Plantagenet Alliance. I would have kicked that out, frankly, on grounds of lack of standing.
Yeah, a clear University of Leicester supporter then.
I think the problem is, though, we've just touched on the importance of public participation, and things like ARHUS and environmental impact assessment. They're all about the public at large. So, for judicial review to kind of move back from its current position of a fairly relaxed view of standing, sort of jars against that in a way, doesn't it? Because who has standing? Answer the public.
And notably, the government, even your proposal is actually stronger than what the government would have come up with, even this government, in that it had a specific carve-out understanding for environmental cases. I mean, it wouldn't have quite covered environmental cases fully, but the intention was to exclude environmental cases in any case from the standing requirements. And I think what I'd say more kind of broadly in terms of this obsession with speed, I think, is it does start off from the premise that development is always a good thing. Development should always be encouraged, it should always be speeded up and allowed to happen. That's almost the default thinking behind which everything else operates. And I think we really do need to step back and consider that thinking. I think it also ties back to, as I said earlier, the third-party right of appeal. You can only appeal a decision if you're a developer and it hasn't gone your way. So there's a presumption that things should be going your way. There isn't a presumption that actually perhaps sometimes these decisions shouldn't be being made. Perhaps they don't match with policy. And if you don't agree with them, you can only go to JR. And JR is a relatively narrow ground. So if you actually had the ability to have a functioning third-party right of appeal where you could reconsider some of these issues, maybe that would relieve some of the pressure on JR. But as long as you continue to have this kind of drive to, yes, we want to just develop, we're not going to think about, we're going to take that as an automatic understood good, that development is always a good thing in all circumstances. And I think that is something that we do need to
Can development
think
ever
about
be a
more
good
carefully.
thing?
Well, absolutely it can, but it's not
Yeah.
always going to be a good thing. And I think we currently proceed on the basis that it is. There's an inbuilt assumption in our system.
The
But
assumption
that's
must be that it is, surely.
Well, not necessarily, no. It depends on the kind of development. It depends where it is. It depends what it does for the locality and the country. And, these are very, very important issues that absolutely you can't just give a blanket response to.
I think the speed, though, the point about speed, though, I think it's less about, development should happen. It's more about addressing the situation we had with, even if planning judicial reviews represented a proportionately small number of judicial reviews, actually it was having a disproportionate effect on the planning process. The fear of judicial review, the fear of delay, meant that behaviour patterns were being established in the planning system where environmental impact assessment became something which lawyers and consultants obsessed over to avoid the risk of a delay through judicial review and so
Well,
on.
that's gone wrong, hasn't it? Because the environmental assessments used to be quite readable, small documents. But just to cover every possibility, they're getting bigger and bigger, and you get a table full. You get a room full for some of these larger. It was literally a room full for the London Gateway Port. That's the environmental assessment. I remember going along, they said, would you like to see it? I said, yes, I would. I thought in these technological days I was going to get a disc or something. Remember disc? You probably don't. That's one of those that today would be on a stick, wouldn't it? And I went, they said, no, it's in there. And I went in, it was literally a room full. And I said, well, where do I start? And they said, oh, there's an index of all these documents. I said, well, where's that? They said, it's in a box. I said, where's the box? In the room. Where about in the room? Well, you go and find it. And it didn't work. It did take us 2 months delay, during which time we forced them, and I've got to say the inspector helped us, we forced them to stop everything, get this all made electronic, and make it available. They put it online at that point.
But it's interesting. In my room back in Chambers, I've got a copy of what I think is the UK's first ever environmental statement. And it was the one for the Hinkley Point C application in the late 1980s. It was actually produced before the regulations had come in the UK, and in response to the directive for a new nuclear power station at Hinkley Point C at that time. It's about that thick.
Yeah.
And
Is it written in English? Is it?
It is written in English, and I gave a lecture recently at Cambridge, and I put up a picture of this thing, and then I put up a picture of the environmental statement for the more recent Hinkley Point C DCO with kind of a pile of paper. And it goes back to my kind of word processing and Xeroxing type of point.
Yeah.
But and therefore, in a sense, we have information. Is that the point that we have too much information?
I was going to sort of chip in on that also. I think from a fracking perspective, I think I would say I see examples absolutely of what you've described, and I see opposite examples as well. So the two most recent fracking applications that one of the speakers was talking about this morning, you're seeing some pretty hefty documents. But what you're then seeing there is an inadequate period of time in which to go through them. So you had 2 fracking applications, 9,000 pages, and 3 weeks to work through them. And that doesn't really seem to me to be an effective process for anybody. It isn't for local people, and it isn't for anybody involved.
But you've got more time in that case.
That case, but only by putting a certain amount of pressure on the decision maker. Conversely, you then also sort of see, you see cases where I don't see a great deal of fear of EIA. Certainly not a couple of years ago. We've seen some quite patchy decisions on EIA screening.
But they're meant to be about the main effects of the development. If you go right back to what's meant to be in there, and I think they have come a long way. I remember very early EIA that I saw many years ago. The conservation nature conservation chapter actually had the line, "There is no nature conservation on the site," which I thought was an interesting start. So they have come a long way, and a lot more detail, apart from a dead bird apparently. But there's actually a photo of the dead bird in the environmental statement, so that's how far they've come. But I think then it becomes no longer about the main effects of the development. It is, as you say, about covering every potential effect in huge amounts of detail as a kind of book down the trousers exercise because they know that someone else is going to go through it looking for things that don't line up or inconsistent as a way of potentially challenging. So they become an industry in themselves now around protecting positions.
I think that's fair, but I think against that we have to bear in mind where the courts now are in terms of the standard of review that they apply to environmental statements, which is actually now quite a high standard. The Supreme Court seems to be sending a message that basically says, unless it isn't really an environmental assessment anymore, don't darken my doors with it. Yes. So I think to a degree the courts have actually been sensitive to some of the concerns you mentioned.
One of the things I'd like to see more of is more independent review of EIAs.
Yeah.
At the moment it's very hard to get that done. There is the Institute who will do something, but a lot of it is sort of tick box, are certain things there. I think actually one of the things that might help is more independent review of EIAs.
Public trust, and I really think all professionals need to work to sort of tell our clients that they shouldn't run scared from the risk of challenge on a lot of detailed points, because as you say, the courts are not going to get involved in the minutiae. Let's have indicative word limits for these things and make them readable by the public, so that
something on shale, for example. I mean, it's if it's new, untried, untested technology with lots of impacts, you'd expect. I mean, I'm not 9,000 pages is actually, as you say, helpful for anyone, but you would expect more on something like that as compared to perhaps a supermarket or something that still falls within the.
I mean, I come back to the point we started on this, which was speed in the process. Isn't that actually important? Because if a challenge point is a good challenge point, it can be dealt with speedily, and if it's a bad challenge point, it can be disposed of speedily as well. And surely that is the right thing for us to do, to allow challenges to be made speedily, so that either the challenger is successful and the developer has to go away and rethink, or the developer can get on with the business of developing. And I don't see that is inconsistent with fairness.
But I don't see the difference between that in planning JRs or any other kind of JRs. No. I mean, JRs are in the public interest. Some of them should be expedited and should be faster, and some of them should be less. And this is effectively saying we are placing a premium on planning cases above. Again, it's this sort of this placing of emphasis or priority on particular areas without, in my view, any sort of statistical basis. Just it's a philosophical or policy consideration that this is what we want to do, whereas actually what you want to do with a system like JR, which is of constitutional importance, is looking at cases across the board, making sure that the really important ones and the really significant ones are being dealt with quickly, and that the other ones wait their turn. And so they may be important to a particular developer in a particular area, but they shouldn't be put any further up than something that actually is more important in sort of real world.
Well, can I say, I mean, obviously other areas of judicial review are equally important to planning, but we've got to think of the planning system as embracing not just the planning application process, where the government has done a lot to really speed things up and introduce targets in terms of timescales, planning appeal process, which is now incredibly front-loaded with a lot of responsibility on the parties to move quickly. And then, you know, the third limb is the court process. So, you know, if the government is serious about making the planning system work to deliver housing, because we talk about the environment and climate change, which is a terrifying prospect and reality, so is the lack of housing. And though that fundamental issue also needs to be addressed, and and so we need to get decisions out through those three stages as quickly as possible. And that's why, you know, the changes are welcome, and you know, we've got to find ways of dealing with the inevitable campaign groups that challenge almost any significant or material scheme for housing development or other forms of economic development, that the democratic element of the decision-making process have determined to be a good thing.
Go on, Jake, one final point, and then I'm going to kind of move us to a slightly different topic.
It was just the other issue I think we have to bear in mind in relation to speed is resources. Is government is going to have to resource the courts to deal with things more speedily, to dispose to dispose of cases more speedily, and you know that cuts both ways. I mean, just as there are potential fairness issues if you're rushing a claimant through a case, equally we've got the possibility of a case, haven't we, at the moment where government itself is not actually capable of responding to our letter setting out our concerns within its own shortened timetables. So it's got to resource itself as defendant as well as itself as service provider.
Well, I'm going to move us on there to a slightly different